That was funny.
My Lord, we've bottomed out the factual issue, and it goes to this point about comfort and the signing of the GFA and so on. You each have two documents in front of you. The first is a copy of the minutes of a board meeting that took place on the 5th of December 2022. Yes. This is the meeting at which EVML formally resolved to enter into the Erigor contract. At page 4, you can see the resolution at the bottom, but the passage that I would direct your Lordships to is under rationale for approval at the top, and it's the last bullet point. In the extremely unlikely event FAB, so that's the Funding Approval Board, decline, EVML have the option to omit 3 blocks.
Sorry, this is on page...
On page 4, internal pagination.
I beg your pardon, sorry.
So my learned friend made the point that the Get Living blocks were going to go first. It was not just that, it was supplemented by this. So this is a document that we've produced, and my learned friend has also produced the email, which you also each have a copy of. This is an email dated the 13th of December, so this post-dates the board meeting. You can see in my submission that solvency is still an issue. Dan Greenslade is the Chief Financial Officer of EVML, and he sets out various reasons. So the first substantive paragraph, he says, well, day-to-day stuff is handled by the service charge. This isn't day-to-day, but he's saying we are still comfortable we can enter into it, and he gives his reasons why.
Yes, I see.
That's all I propose to say.
Thanks very much.
I'm grateful.
My Lord, I did hand up the speaking notes, and I have circulated them. Before I address you on the speaking notes, there is one general point that I wish to make on behalf of my clients, the 32 leaseholders at Hippersley Point. And it really arises from the way that the triathlon discussions are taking place. For example, my learned friend, not only learned friend, but also my friend, Mr. Polly, spoke with passion and force about practical difficulties that a management company might face in the event that the arguments that I advanced on Tuesday were made out. And indeed, as part of the other arguments, and I'm going to come back to them in due course, as part of the other arguments, there were a lot of references to the way that one should approach the leaseholder protections in Schedule 8. That discussion took place between a management company, a developer, and landlords. And yet it was about leaseholder protections. In this pair of appeals, there are only one set of leaseholders who are represented. The 32 leaseholders at Hippersley Point. They had the misfortune to purchase leases of flats in a building that suffered from building safety defects, including, according to the leasehold valuation, the FTT, flammable cladding. And during since the precise defects were identified back in 2000, those defects have not been remedied. Reference was made at one point, for example, to the suggestion that an application under Section 20ZA benefited the lessees because it got the work done more quickly. Well, in practical terms, that has not happened at Hippersley Point. And whilst the lessees have had their flats blighted in a building which suffers from significant building safety defects, in order to add insult to injury, they were met with service charge invoices for £1.8 million to cover the cost of remedial works. Now, they are fortunate enough that due to the government and eventually the developer, that they have had those service charge demands withdrawn. But they were hanging over them for the best part of 2 years. Mr. Murphy, in his witness statement, identified the average projected cost of reinstating building safety defects in buildings at £59,000. Now, the one at Hippersley Point, he was pretty much bang on, because simple arithmetic, £1.8 million divided by 32 people provides a figure of 56,250, an average service charge, set of service charge demands, not including, of course, the Section 20ZA application costs, which are in effect the subject of this appeal, of the appeal. So when it comes to the landlords and the management companies in Hippersley Point, in Adriatic, in Triathlon, lining up and advancing arguments on the meaning of the protections in Schedule 8, my clients are entitled to feel somewhat aggrieved, and I've already gathered that in the light of my my speaking notes, you may well be faced with another barrage of attempts to respond to what my comments are. But in any event, we are where we are, and emotion and passion doesn't, of course, answer the questions that you have to answer. And in effect, from the point of view of the lessees at Hippersley Point, they want two questions answered. Firstly, are they liable to pay, are they protected by Schedule 8 in respect of the costs that were not only incurred but also invoiced to them prior to the 28th of June 2022? And secondly, how do they go about dealing with any issues in practical terms? Is it going to be by way of a Section 124 application? Is it by way of an application in Section 27A of the Landlord and Tenant Act? How are they supposed to deal with any overpayments that may well have been found? So that is the background to what we say about the issues that have emerged from triathlon, because in my submission they have influenced, they have shifted the discussion that we had in the Adriatic appeal. And to understand that, it's necessary to go back in my submission to look at the way it was originally put in the skeleton argument of the appellants. And we were, I should say, a little sceptical.
The Adriatic.
In Adriatic. Yep. And that is at tab 2 of the core bundle. I'm only going to be referring to the core bundle if it helps. At 30 to 31. And you can see that as my Lord Justice Nugee said yesterday, there is no doubt that under paragraph 9, a landlord cannot recover a service charge if the costs were incurred after 28th of June 2022 and the service charges would otherwise fall due after that date. And as he said, and I think it's common ground, everybody accepts that. But the various retrospective constructions were dealt with in the skeleton argument at 30 to 31. And it was put in three ways. The first of those was described, and I'm looking at tab 13 of the core bundle, page 119, tab 2, pages 30 to 31, should be. said, yes, here we are. So the first was the prospective construction at the top of page 31. It may apply only to those legal costs and professional fees that were incurred after the provision came into force. As I understand it, that is and remains the appellant's primary argument in this in the Adriatic appeal. There are certain similarities with the arguments on retrospectivity in triathlon, although obviously the provisions are rather different, slightly differently worded. Obviously that primary prospective construction is opposed by the respondent, by the lessees, and also by the Secretary of State. Then there's the second, before I mention it, I should say that was an approach that was rejected by the Upper Tribunal. I've given the references in paragraph 2 of my speaking notes. Then there was the retrospective construction, which is the one that I advanced the other day when I addressed your lordships. Although it's not entirely clear what the position is with some of the other parties, that was plainly accepted, or the Upper Tribunal adopted that position, considered both the prospective construction and the intermediate construction, and it rejected the prospective construction. And we are the only ones who advocate that, as far as I can identify, across both of the cases. And it's opposed specifically by several parties in triathlon. Secretary of State, the second respondent, were perhaps two most notable. Which leaves the third approach. Now, I started off by saying this leaves Sir James Eadie's approach. I gather that is controversial, so perhaps I ought not to lead with saying it's his approach. But there is the intermediate construction, which was dealt with in the skeleton argument. And that was, as it was put, that it may apply to legal costs and professional fees that were incurred before the provision came into effect, and therefore recoverable, such that identifiable certain contingent right to recover had arisen as a result of law prior to that date. Now, that's the way it was put, and as I understand it, that is still the secondary argument raised by the appellant in Adriatic. That was, again, rejected by the Upper Tribunal. I can take you to the passages, they're referred to in my notes, but I can take you to that.
I don't think there's a need.
Now, it's understood that's still maintained by the appellants in Adriatic as a secondary argument. As far as I could tell, and I'm going to qualify that in a moment, it was adopted by the respondents and the Secretary of State in triathlon. Now, I say that because, as I understand it, the actual position of the Secretary of State is a nuanced version of the intermediate construction. It's not that it is where legal costs and professional fees that were incurred before the provision came into effect, but perhaps had not become payable in the sense of debt not having fallen.
I think my understanding is the Secretary of State's position is it all turns on whether the money had been paid.
Well,
if it hadn't been paid, it isn't payable. That's that.
Well, I would submit that there's no distinction between that and the intermediate construction. And the reason for that is the word payable. It doesn't say paid.
Well,
it says payable.
I may be misunderstanding. As I understand it, to the extent there might be a live issue in this sort of area, It's over what you do where the service charge has become due, the costs have been incurred and they have been billed, but they have not yet been paid. And the Secretary of State says, well, still, because they haven't been paid, that's that. That's my understanding.
Sorry,
Mr. Walsh is agreeing with that.
That's that Schedule 8 does apply to protect the lessee's liability.
That's, I think, is Sir James's position.
Well, what I would say about that is that is an artificial distinction. I think it's difficult to see how the word payable can suddenly become the word paid.
And if it's being paid, it's no longer payable.
Well,
I suppose.
Payable would normally mean, as is suggested by the appellant,
It's due irrespective of whether it is being paid. Yeah.
So it's what I say is that by conceding that point, if I can put it that way, with the gloss on it that it covers those who have it only protects those who've actually coughed up the money. That opens the Trojan horse of the
only people it doesn't protect are the people who've coughed up the money.
Sorry?
The only people who aren't protected are the people who've coughed up the money.
Yes.
On that basis.
And in a sense, this was the gist of the respondent's objection to the appellant's interpretation. We say that it made no sense that Parliament would make that kind of distinction between those who have not only on, let's say, on the 24th, on a quarter day, 4 days before the Act came into force, which is a very common day for liability to pay service charges. If some actually had the misfortune to have paid their service charge demands on the 25th by standing order or whatever, and some paid by the end of the week after the Act came into force, there is no obvious indication why Parliament should have intended that to have been the consequence.
I suppose we can assume that if people have paid, not necessarily, but generally, they would have received a demand. People won't normally pay in advance.
Yes, there needs to be.
So, in either of those two scenarios you've just described, the debt has fallen due. And your submission is, why, given that that's common to both, why would Parliament have drawn the line of retrospectivity in the way that Sir James suggested?
Exactly. And this is why I say that the intermediate construction or the intermediate or Sir James's version of the intermediate construction is that both of them are wrong.
Yes, that's
because there's no indication that, in a sense, it makes even less sense, Sir James's distinction in terms of time.
Well, then it gives rise to the argument against retrospectivity that it draws a distinction between those who've paid and haven't, which the tribunal grappled with, and they said, well, you know what they said, but that's your submission.
That's our submission, but. May I move on to something else, which arises from the way that it was put in Triathlon, the point is this: that during the course of argument, a number of statements were made to do with the position under Section 124. And we have a case which has been referred to, I referred to it earlier, a case called Batiche. It's only a First Tier Tribunal decision. But nevertheless, it's an example of where lessees deployed Section 124, argued Schedule 8 protections in relation to service charges which had fallen due, which had become payable before the Act came into force. Now, Mr. Nissen, for the first respondent, as part of his argument, I appreciate these are all building blocks to argue something different in their case, but nevertheless, he said that if the leaseholders lose their case in the Adriatic case, they may, on my analysis, go for an RCO subject to scope about whether costs of an application fall within it. So the suggestion was that there was that even under that right under Section 124 would a Batiche type application be permissible. Mr. Polly said much the same. Our position is also that Section 124 can apply back to costs incurred prior to 28th June 22 because it doesn't suffer from the same problem. Mr. Walsh, and I've quoted them here, and that's why no doubt they'll all be standing up, wanting to stand up and say they wanted to say something different. But actually what I am submitting is there seems to be a general consensus in triathlon that Batiche type applications in this situation are a permissible route. Indeed, Mr. Selby, I say Mr. Selby adopted Mr. Walsh's approach. That's unfair. I appreciate that. I think he was referring to Mr. Walsh's submissions on that. So I think that's slightly unfair. I made a misnote on that. But he certainly referred to Mr. Walsh's propositions. So what we say is that it might well, therefore, open up an alternative to either the intermediate construction, which I call intermediate construction plus, or a variation on Sir James's submissions, and it actually matters not which of those two it is for present purposes. And that is that that it is retrospective in terms of the costs that were incurred by a landlord, which is obviously common to many of those submissions. But if it's shut out by the intermediate interpretation, or Sir James's interpretation, and sums have actually been paid or have become payable, however you look at it, before the 28th of June 2022, that this court could indicate, provided of course you find the right way in triathlon on the meaning of Section 124, to say that that is the route that a lessee who is covered by Schedule 8, who has incurred the costs and may even have paid service charges prior to the 28th of June, and who seeks some remedy, should go down the Section 124 route. And in my submission, if you are to find for that alternative approach, caveating with the Section 124 indication that I've already given, in my submission is entirely consistent with certainly the respondents and the Secretary of State's position in triathlon, and would provide an answer to the second question that I put to you about from the lessees, from my clients. If they have a remedy under Schedule, if they are protected by Schedule 8 in respect of costs that have been incurred by a landlord prior to the 28th of June, that they can, at the very least, go along the Section 124 route and make a Batiche application. Now, if that's right, we're really only talking about a matter of process. Is the process that the lessees should invoke, can go down the route of paragraph 10 and feed into the conventional service charge machinery and the courts and so on, the tribunals and Section 20ZA applications and so on, or raise it as a defence in county court proceedings and do it that way? Or procedurally, do they have to make a Section 124 application? Now, one can see that there are some advantages to making a Section 124 application. It would go some way to meeting practical concerns raised by various respondents in Triathlon, that there may be problems with high service charges levied on leaseholders which have been paid and would need to be reopened, that it would meet the 15-year fire door issue because the tribunal would exercise a just and equitable jurisdiction, and it could weigh up whether it was ridiculous for a lessee to ask for its service charges back 15 years later, or whether that should be balanced against other considerations. And obviously it would provide some consistency, depending on how one looks at the self-contained code or the composite package, or however it's described. It would certainly keep it just within the envelopes of that self-contained code, and it would continue the approach that was obviously adopted in Batiche as an option. But what we come back to is that ultimately it is a question of process in the end, and it's interesting to hear the discussions that have taken place in Triathlon about the TCC procedure, which is of course easy and seamless and clear, or whether the courts are transparent, easy and clear, whether the First Tier Tribunal procedures are the same. But all we would say on that is there is a world of difference between requiring the lessees procedurally to go down the Section 124 route and being able to invoke Section 20ZA jurisdictions in the tribunal. My guess is, even if this court did decide to say that the Section 124 route was the correct one, the tribunals are nevertheless going to find many, many leaseholders acting in person who may well be still relying on Schedule 8. They will have to tell them to go away and reissue using the correct jurisdiction. And there is a world of difference between them. I've cited some figures which are available on Freedom of Information. There's over 3,500 applications made to the First Tier Tribunal using its management jurisdictions, of which the vast majority are Section 20ZA applications each year. They do huge numbers of these applications. The number of Section 124 applications that are made are relatively low. They will involve leaseholders rather than simply saying to the landlord, we don't have to pay, because Schedule 8 says we don't have to pay. They will have to consider whether a developer, whether other connected parties might well be the proper recipient of an RCO. And it is a very different proposition from the relatively straightforward procedure of raising a Schedule 8 defence in a Section 20 ZA application. And ultimately, as I submit, it's a question of procedure. And did Parliament intend one or the other? And in my submission, the answer is, and reading the words of regulation of paragraph 10, looking at the way that there are multiple references to the 1985 Act, including the references to in section in paragraph 10.2, which are directly lifted from section 19.2 of the 1985 Act about making adjustments for overpayments and so on. Plainly, it was Parliament's intention that was the route, rather than through a section 124. So we don't resile from our submissions that the full retrospective construction approach is correct. Despite everything we've heard in the triathlon case, and we don't, we say that's the mechanism. Paragraph 10.2 is the way it feeds into existing legislation. And neither can we agree the intermediate interpretation or the Secretary of State's variation on that. What we say is that if that is to be adopted, very much a second best would be to couple it with an indication that we have rights under Section 124 to revisit any service charges that have been already paid or payable, depending on the approach that this court takes. If there's anything else, those are our responses to trial.
That's very helpful. Thank you very much. Mr. Allison.
I do have a written... It's taken lunchtime to turn it into a form that's faintly acceptable to the court, but if I can hand it up now. My Lords, first of all, my apologies for the note in the sense that it was written for my purposes, not in the form of a skeleton argument. So whilst it looks and is about twice as long in pages as Mr. Loveday's, it's because it's written in a more full form, and it may, of course, mean I can skip along a few points where there are points of detail. Can I just make one point, just that's not in the note, but is in response to something Mr. Loveday just said? He was just referring to the fact that there could be a degree of confusion, leaseholders not knowing whether they're meant to pursue a Section 124 route or a Schedule 8 route. Putting aside whether that's right or not, we are nearly 3 years after the Act was passed. The issue in this case relates to costs that were incurred pre the Act. So this isn't an issue going forwards. It isn't a prospective issue. We all agree Schedule 8 captures it. So if there was a big difficulty with the earlier cases, in my submission, we know about it by now, but in any event, it must be a diminishing problem. So I say that's not a great factor.
I suppose it might still be a factor bearing on construction, in the sense that when the legislation was being passed.
Yes, but I'll turn to that in a minute, but the short answer is, well, if Section 124 has retrospective effect, that is this part of the scheme. That's the short answer, because it as you know, my submission is that by having a solely prospective construction, that gives you that clear cut-off. It's costs that were incurred prior to 28th of June are not caught. Only costs after are, you've got that bright line, you get the same outcome for all leaseholders, whether they're paid or they haven't paid before the Act.
And just, I haven't read, yet looked at your note.
No.
Just so I'm clear, picking up Mr. Loveday's point about process, it is your submission, isn't it, that a leaseholder who had paid could seek an RCO because Section 124 is retrospective? Or do you not go that far?
I don't take. I'll turn to it
Yes,
if I may, because essentially what I say is, you can see the arguments both sides. That illustrates a degree of ambiguity. I don't want to take a firm position
Yes,
on
I
it,
see.
but yes, it suits me if it's retrospective because it fits better in the scheme.
Yeah, I follow. So just following that hypothesis one moment longer. So suppose that were the position, that where a leaseholder has paid before the Act comes into force, they are stuck with that in terms of Schedule 8. But suppose that they could apply for an RCO under Section 124. What do you gain?
What do I gain? I mean,
Just to be clear, I want to understand why does the leaseholder then say to you, well, I'll have the money back, please, by way of RCO?
Well, the answer is that it's up to the tribunal to decide whether that would be just and equitable. The point is you have an inequality of position because, to take the example of the 24th of June payment date, it's completely arbitrary whether a particular leaseholder either has to pursue that remedy or they don't. And from the landlord's perspective, it's totally arbitrary as to what they are subject to or what they are meant to refund, depending on how we read all the other provisions. And that can't have been intended. And that's a point that's been made in Triathlon as well.
Yeah.
And you resolve all of those oddities by having a retrospective construction on the Section 124 position, by having a prospective in the sense that I say construction based on when costs are incurred, on paragraph 9 and indeed the other protections that relate to paragraph 10. But I think I will touch on it in a moment.
I ought to let you develop your note, yes.
I've started off with just a few points of reply. Some of them are bits of detail. There was some discussion, I think it was on Wednesday morning during the course of Mr. Selby's submissions, about what liabilities are imposed on landlords by Schedule 8. You recall we looked at, people taking Section 116 and 122 of the Act, they refer to liabilities being imposed, and the question was what those liabilities were. I think it was my Lord Holgate suggests those liabilities might be imposed by paragraph 10. So I just want to be clear, my position is paragraph 10 does not impose a liability on a landlord. It did give that example that Mr. Loveday has run with, of if paragraph 10.2b requires a landlord to refund everything, that creates an odd situation. But I don't say that's a liability. At its highest, it's an obligation to refund the monies to leaseholders where they've been incorrectly charged. What I don't think we picked up on earlier is that the words in paragraph 10.2b, so the words in parenthesis, and any necessary adjustment must be made by repayment, reduction of subsequent charges or otherwise, is identical to the wording in section 19.2.
In the 85.
In the 85 Act. So it's yet another example. Mr. Loveday is nodding, so it's not controversial. It's another example of how Parliament has dovetailed to a significant degree the leaseholder protections of the 1985 Act. Paragraph 9, just section 19.2 deals with the reasonableness of charges charged on account, so estimated sums, so it's referring to that balancing exercise. So I say the liabilities that are created on the Schedule 8 are solely those under the LPI regulations. No one's been able to point you to any others. Those are given teeth by paragraph 12 of Schedule 8, but it's worth noting the LPI regulations themselves did not exist when the Act was working its way through Parliament. And you may recall I said even when the Act came into force, the regulations to make it work were not in force, and indeed one of the sets wasn't even published. So these LPI regulations, they come in late July. So it's dangerous to draw conclusions from the LPI regulations, but equally I accept it was always envisaged by Schedule 8 that something of that type would be there. My next point is Mr. Selby, with respect to the interaction between the facts of Adriatic and Hippersley, sought to distinguish them by saying Hippersley just focused on the phrase, not on whether costs were payable and not on the phrase whether costs were incurred or to be incurred. I think you probably had this point. I say it does entirely turn on his words, so just to be clear about that.
Just to be clear, does your case need to turn on those words? You find in paragraph 9 payable.
Yeah.
You find the idea in the cases that there is a presumption against retrospectivity. You find the idea that you need clear words to impose retrospectivity, particularly in relation to accrued rights. Why couldn't your argument, were it well founded, operate in relation to payable without any regard to incurred or to be incurred?
I say it could, but I say I don't need to go that far because you can see in paragraph 10 it is defining what the words no service charges payable means. And that is done by reference to expressly to the use of the phrase costs incurred or to be incurred, which is a very well known and well used expression in landlord and tenant legislation and has been for many years. So it's simply that our starting point is always, what do the words mean? What are the words used and what do they mean? So if the words are there, I want to use them. My Lord, I entirely agree that you can do it just based on paragraph 9. I think I did say that on Monday, albeit I said that lends better support to the intermediate construction because it does focus on payers. There's a very brief point of paragraph 3 that I'm going to skip over very quickly in the interest of time, but it relates to those.
Can I just make sure I've followed the submission you made? By reference to the LPI regulations, which you say explain the only liability
yes.
which arises from. Those regulations are made pursuant to, is it paragraph 12 of Schedule 8?
Yes.
I mean, that will be clear from the covering sheet of the regulation.
I'm not sure if it is.
Well, normally it is. Yeah. It refers to the rule-making power.
It says paragraphs 12, 13 and 15
there it is,
of
yes.
Schedule 8.
Yeah, thank you. But liability is not a concept. Is that referred to in paragraph 8? A liability of the landlord?
In Schedule 8?
But yeah, Schedule 8. This is the submission you're making in your note. The liability is referred to in the Act and arising from Schedule 8. Does Schedule 8 impose liabilities on landlords?
To the extent it imposes liabilities on landlords, the only way it can do that is through the LPI regulations.
Yeah, so that's making adjustments as between different landlords.
It is. So to give an example, a landlord incurs a cost and
it's not dealing with the relationship between a landlord and a tenant liable to pay a service charge.
It's not addressing that. It's addressing if a landlord is left with a cost that it cannot recover by way of service charge, it might be able to get it from other parties under the regulations.
Yes.
And that means other parties under the regulations will be subject to that liability that they otherwise would not have.
Thank you.
I think I'll leave paragraph 3 with you. Essentially what I'm saying is the 2024 Act is entirely equivocal and takes you nowhere. And that's my short point. Yeah. Paragraph 4 is sticking with the LPI regulations. And so I think it's important to understand what they achieve. The passing Triathlon took you to them in detail. But it's worth remembering, in my case, a paragraph 9 case, it's only regulation 5 that's engaged. It's not regulations 3 and 4. Because regulation 3 applies where it's a paragraph 2 case. Regulation 3 applies where it's regulation 4 applies where it's a paragraph 3 case. So paragraph 5 is where paragraph 9 sits. All that regulation 5 achieves is splitting the cost between the landlord and other landlords that have an interest in the building. In the vast majority of cases, there is no other landlord. So to take Hippersley point, my client has the freehold interest, it grants some leases. Putting aside that's part of the commercial landlord. That's the usual state of affairs. So whilst it does have application in complex developments, we have head lease arrangements and housing associations that take particular blocks and so forth. The vast majority of cases, the very complicated formulas you see there turn into the answer is you have to pay it all and there's no one you can go against. The other purpose it achieves, and this is the far more important purpose that it's worth appreciating, is where you have tripartite leases with an RMC, an RTM company, a named manager. It is the way that they recoup their expenditure from the landlord. Because the policy is that landlords have broader shoulders than the managers, which in most instances must be the case, notwithstanding everything we tell you that our shoulders are small because of the ground rent. Management companies have no income and they're non-trading entities, so it's a relative thing. They would fail but for that. So that is actually the greater purpose, and thereby it's imposing liabilities on landlords. So a landlord in a tripartite lease would normally not have any responsibility to pay, and that imposes that liability on the landlord in place of the manager, even though the landlord doesn't have the repairing obligation. Where does that all take me? Let's just say that the effect of the LPI regulation shouldn't be overemphasised, because Mr. Walsh's submissions were to the effect that there's a multitude of other routes to pursue. So essentially this goes to the fairness of retrospective effect. He says, well, there's the LPI regulations, there's BSF funding, and there's Section 124 applications. But if we think about the facts of any given case, it's clear that that doesn't provide a great answer in many cases. The Building Safety Fund will not cover costs that don't relate to cladding remediation. And you can see in the witness statements filed by both parties on the A1P1 points, an awful lot of the difficulties relate to internal compartmentation issues. Billions of pounds, possibly more than the cost of the cladding. A huge amount of money is not in receipt of any grant, will need to be spent with no grant funding. The LPI regulations don't help in many cases, as you can see. And in terms of, so then we're just left with RCOs, Section 124 applications. Well, really, if the answer there is you're going after a developer, if the developer is one of the big developers that has the money, they're probably in the pledge. If they're not, a lot of the time you're in difficulty and you're chasing entities and associates, or they don't exist. So
just to be clear, in the circumstances of your case, well, on any view, you've got a great shortfall now because you're not getting in service charges in relation to any money spent since June 2022, I assume. Or had you done all the work before June 2022?
No, the work hasn't been done.
Oh, I see, yes. Yeah.
Because we were just about there, and then
yes.
Building Safety Fund got frozen, the developer pledge.
So sooner or later, work will be done in circumstances where you can't get in service charges.
Yes, but the expectation is, in our case, that the developer will. I mean, yes. Everyone's keeping their fingers crossed.
No, I follow all that. But in the hypothetical case,
yes.
Somebody in your position, their remedy, if they had one, would be to RCO the developer.
Yes. Which is subject to their solvency and subject to justice and equity.
Yes, that's it.
My only point really here is there are these other routes that Mr. Walsh identifies, but in many cases none of those factors will assist. So when you come to fairness, it shouldn't be assumed that those checks and balances are actually going to assist on the facts of any given case. Of course, you need to determine this on the basis of what the statute means for all purposes, but that means you've got to bear in mind there's many examples of cases where those three safeguards, if they are one, are worthless.
And that means, if you're right, and paragraph 9 of Schedule 8 is only prospective, fully prospective, it's the leaseholders who are faced with service charge demands for past costs, still have to pay them, and they have the Section 124 route, but that may not produce anything, for all the reasons you just said.
Yes.
Say that then they could RCO you.
Yes, and it's not a point, I don't think, that's going to be entirely decided on this appeal as to how the tribunal should approach applications by leaseholders against landlords that have nothing to do with the development.
But at any rate, a leaseholder would have an extra target as compared with the landlord.
They would. But the greater point in my submission with response to that point is, unless the landlord is associated with the developer or was the developer, they are no more culpable for the position they're in than the leaseholders, and they have the lesser interest in the building.
Yes, I see.
You have the evidence on that. In rough terms, the ground rents will be 2.5% of the overall value in the building. It'll vary enormously, but not that. It's that sort of region of 2.5%. You have the maths of that.
No, I follow that. So in terms of Mr. Loveday's point about it's just process, you say, well, it's not obviously just process at all, because a landlord might be able to resist an RCO.
Yes, so might a developer. I mean, it's not a complete answer. That's why it's less egregious on the retrospectivity, is because you've got that check of, is it just an equitable? What are all the circumstances? Not an automatic write-off. My paragraph 6 is just a brief point. Mr. Polly gave the example of, well, here we are, the management company, and we've spent all this money, and we're going to be in difficulty if we suddenly have to refund all these monies. At that point, I thought, oh, excellent, Mr. Polly is supporting me on this. And then it didn't quite come home. But actually, it was a good illustration of the difficulties all sorts of people find themselves in if paragraph 9 and thus by extension paragraphs 2 to 4 and 8 have retrospective effect, particularly in the sense Mr. Loveday argues. So it was a good illustration of that. I want to come back to the point which I think was interesting you earlier, which is the interaction between the appeals. It does suit me for section 124 to operate retrospectively for the reasons I've already set out, but there are obviously competing arguments on that. You heard from Mr. Selby, well, it doesn't need to because leaseholders have a remedy, and you'll have your own view on how satisfactory it is having to pursue court proceedings as opposed to tribunal proceedings, but in fact, Mr. Selby dealt with that a little earlier today. But of course, equally, I go back to my earlier point, many landlords and leaseholders are no more culpable than the other, and it's sort of preserving the status quo to leave section 124 not having that prospective effect. And I've already addressed you on this in the context of our appeal. If it's so fundamental to the scheme, as the Secretary of State says, where are the indications of that? On the other hand, we then have Mr. Nisson's position, and he pointed fairly in my submission to the fact that if section 124 doesn't operate retrospectively, the statutory scheme would preclude those who reacted promptly to the Grenfell fire from having the remedy, whereas those that delayed would have it, which is the point, as he says, that we make in our skeleton argument of paragraph 65. So I then find myself nodding in the other direction. But that's the equal treatment point I was referring to earlier, and I say that's a compelling point, because just as you need it to be retrospective to not have that difference in treatment between leaseholders depending on whether between parties depending on whether or not they acted promptly or not, the same is true with paragraph 9, because unless you focus on when the costs were incurred and you have that fair cut-off, basing it on whether people paid or didn't pay just after the quarter dates results in those unfair and I say unlikely to have been intended consequences. So that point works in both appeals. We also, of course, have the fact there is that you've got the just and equitable test for section 124, you've got your saving provision with section 135 and section 149. There is nothing in paragraph 9. I'm now on paragraph 8. How do we tie them together? I think Mr. Walsh suggested there's no need for the phrase incurred or incurred to be incurred to mean the same thing in the Building Safety Act as it does in the Landlord and Tenant Act legislation, because as he says, it's a freestanding scheme. In my submission, it would be a far more satisfactory solution and a far better way of reading it if it does have the same meaning everywhere. It's the same formulation of words, and it's been used in a similar legal arena, landlord and tenant, residential legislation. So I disagree with Mr. Walsh on that. And paragraph 10 compels you to read Schedule 8 in the context of the 1985 scheme in terms. And it is borrowing multiple phrases. The paragraph 10.2b phrase, that's the words in brackets, incurred or to be incurred, the reference to costs being payable. These are all very, very familiar concepts in landlord and tenant legislation, particularly from the 1985 Act. You've got some examples from the case law as well of how it's all applied. What I did do earlier in the week was refer to the wrong case in the context of whether a cost has been, when a cost has been incurred. I referred to the Shulen B case, but it's on a slightly different point. It's in fact a case called Burr and OM Property that gives you the answer to when a cost is incurred. The decision of this court, and you have it in the last tab. The authorities, the additional authorities you were given today.
Do we need to look at that or not?
It's not in dispute amongst us in any sense that a cost is incurred, roughly speaking, when you get the bill, not when you call up the solicitor and say, can you instruct me? Which is the point I made earlier. So it's not when the costs are rendered, it's when you get the bill is when a cost is incurred. It's quite a short decision. It deals, but it's quite helpful in looking at how that phrase fits within the statutory scheme. And in my submission, Mr. Walsh was wrong to say that using incurred in that sense in section 124 doesn't work, because it doesn't need to be a service charge for the phrase to work. The question is when the cost has been incurred. And if you think about it, in section 124, applications incurred can mean when you've received a bill, because if you haven't received a bill but you've instructed the contractor, it's the cost to be incurred. So it works perfectly well as a matter of construction. The difference, and this is what Mr. Nissen noted, is that in paragraphs 9 and 10, the words are used in the context of a wider picture within the definition of no service charges payable. And as he put it, the control mechanism might be how you construe payable, but it's still by reference to costs incurred or to be incurred. So they do align. I've then set out the different forms of construction. I didn't think this was going to be controversial. Mr. Loveday's, having heard Mr. Loveday, I think he's saying that the Secretary of State's position is that of the intermediate construction in my case. That's not my understanding, and it's not Mr. Walsh's understanding, because we understand it to be that the Secretary of State says the Upper Tribunal was correct.
Yes, I think the Secretary of State's position is if it hasn't been paid, that's that.
Yeah, yeah. So you'll see that this related to a discussion with Mr. Selby, and I can't remember which of you, about how the parties were putting the words, and the Secretary of State's construction required the insertion of the most amount of words. No service charges after the 28th of June payable, so on and so forth. You can see it in the paper. Mr. Loveday's construction was just no service charge is or ever was payable, and then my position was being summarised as being no service charges payable under a qualifying lease in respect of legal or other professional services rendered up to the 28th of June. And I just wanted to pick up on that, because we have talked at length about contingent rights that arise from the moment the service is instructed, from the minute we pick up the call, can we instruct you please? But I've also been clear about when a cost is incurred, which is when you get the bill. So whilst the loss of the cost of legal services rendered but not yet incurred prior to the 28th of June 2022 is another degree of retrospectivity, and I do say it doesn't have retrospective effect, I should be clear my case has always been that it's by reference to when costs were incurred because of the words in paragraph 10. So my case has been no service charges payable under a qualifying lease in respect of legal or other professional services incurred after 28th of June as a result of, as opposed to by reference to when the services are rendered. But I have no objection to the rendered construction for obvious reasons. Well, going back to your point, maybe you only need to focus on paragraph 9. In that case, if we just say that shouldn't have retrospective effect because of the presumption, really that would go back to when services were rendered, when they were instructed. When they were contracted might be the best way to say it, when you became under a legal liability to pay. Probably isn't the phone call, it's probably when you get the contract or the retainer in the case of legal service. But my case has always been focused on when they're incurred because of the use of the word incurred. So I just wanted to be clear about that. Sorry, one more. I now want to just finish off on retrospectivity, and I'm done. And really, it's to compare and contrast how retrospectivity is viewed in the sense of section 124 compared to paragraph 9, because we've talked about this sliding scale of fairness. I started out on Monday morning saying this is an appeal about fairness. And it's a factor, it might not be determinant, but it is clearly a factor on the authorities. Section 124 is a new remedy available to a wide range of people, and you have that safety valve of the just and equitable test. And you can easily understand the characterisation that Mr. Nissen adopted of the Section 124 jurisdiction as being in substance prospective. I don't agree with that. I say it's less retrospective than paragraph 9. I'm not sure I can accept it is in substance prospective, but it is certainly a new right from the 28th of June 2022. Paragraph 9 is different. If the Upper Tribunal was right, it involves unravelling existing accrued rights arising under an existing contract with no safety valve, no saving for A1P, no guardrail, as Mr. Walsh put it. And I say that's significant because it's a restriction infringing existing rights, which is it's of a very different nature to the creation of a fresh cause of action, even if that cause of action relates to historic matters. Paragraph 9 doesn't need to have retrospective effect for the policy intent to be met. Unlike the Section 124 position, people who incurred costs before paragraph 9 existed did do so with no expectation their ability to recover would be retrospectively curtailed. So my client incurred the costs not expecting all those debts to be written off at some point in the future. Nobody did anything pre-2022 thinking that an RCO would be available. So people haven't changed they haven't changed their behaviour. So we come back to what do the words mean. We've got the presumption against expropriation, the Horner principle, and the presumption against retrospectivity. They work alongside each other. And in my submission, the reason I didn't agree with Mr. Walsh's note, other than the fact that I didn't get a chance to look at it till relatively late because I was engaged in something else, is whilst it does, I don't say it sets out anything incorrectly, but the focus in terms of the authorities in the Section 124 sense is somewhat different from the line of authorities where you're dealing with a straight expropriation, no compensation, no safety valve, debts written off overnight, is sort of following on from the Horner line of expropriation, is very different from working out, well, is it retrospective or is it not? Is it just a tax on future costs in this sort of line of authorities? So when we read them all, that's not to say there's a difference between them all, but the answer that you get to is very different. The Granada case is a good example of that. Really, that's prospective in the Granada case. It's a very different situation. Whereas I think in my note I referred particularly to paragraphs 55 to 58 of Granada. I think you were taking to them earlier, so I won't take you to them now. Ultimately, the Granada case is a classic example. You had that safeguard of the reasonableness test and the ability, in fact, to appeal, I can't remember where to, the tribunal, I think, if you didn't accept the assessment. Whereas an independent tribunal would assess reasonableness. Paragraph 9, none of those safeguards exist. So we come back to our case. First of all, we say paragraph 9 is ambiguous at best. Each of the parties' respective interpretations require us to read into the Act certain words to clarify the meaning of provision. You've seen where I've done that in my notes.
I just pause there. I mean, in one sense, yes. If we were to accept any of your submissions, one would have to import an understanding of what it meant. But if you compare with, say, Wilson and First County, where you're dealing with Section 3 of the Human Rights Act, which is just expressed in general terms. And they say, well, that doesn't operate retrospectively. They don't spend their time debating what words you would be reading in.
No, I accept that, but the part of the test is to understand, did Parliament really intend this to be retrospective?
Yes.
That does require an analysis of the words used.
Well, yes, but not purely. These cases go either way, partly, possibly mainly, because of the purpose of the legislation which the courts divine.
I certainly accept that purpose must be a factor, and again, that's...
And if the purpose is sufficiently clear when you read the way the various parts of the Act fit together, the architecture of the Act, that may well tell you what the answer is when you look at whether a particular provision is retrospective.
Yes, it may do in the right case.
And to what extent?
Yes, but I say it doesn't here, because the Act works
but it's
just
not
as
just,
well.
as my Lord says, it's not just a question of a linguistic exercise of trying to imagine what words to read in.
No, I accept that, but perhaps we don't have to rely on the presumption. If as a matter of straight construction, that isn't what it means. So the starting point is what do the words mean. The second point...
So you mean, what would they mean if you didn't have the construction, if you were just applying ordinary principles without any presumption? Yes.
Because you might not need the presumption.
No.
So you have to start with what are the words, what are they saying?
And I dare say, I may be wrong, but I dare say if you didn't have the presumption, Wilson First County would have been decided differently, because there was nothing qualifying the language in Section 3.
Yeah. Yes. So, well, does that answer your question as to how I say it fits in? Whether you're satisfied with the answer or not. I think what is clear is that once we're dealing with the presumption, the degree of unfairness is an important factor. And the greater the unfairness, the more we can expect Parliament will have made it clear if that unfairness was intended. Whether that's from the words used or from looking at the purpose of the scheme, it has to be clear. And we know Parliament's done that in a number of other examples, and it hasn't in Schedule 8. But really, we say this is right at one end of that, because you don't have the safeguard. It's removing accrued rights. There's far more than Section 124 by imposing future liabilities based on past facts, because it's extinguishing existing rights, tens of millions of pounds on the evidence across industry. And that is an expropriation from one party to another with no compensation. That's a very strong factor against a retrospective construction. I address you the other day on the fact there's no clear indication that retrospectivity was intended or was really particularly thought about. The overwhelming impression in my submission one gets from all the evidence, admissible and otherwise, is it simply wasn't considered until after the Act was passed. It wasn't Parliament's clear intention. And really, as a result, I say, when you look at all the factors in this case, but particularly the lack of the safeguards, particularly the straight transfer and the fact that the scheme just doesn't need it to work, if we get as far as having to rely on the presumption is firmly engaged. Well, unless I was to say further.
Thank you very much. Thank you all very much for your submissions, those who had speaking roles and those who haven't. And thank you too for those who have been in court earlier in the proceedings but aren't here now. If I've got it right, 2 of those in court now are taking silk on Monday, and one who was in court earlier in the week is also taking silk on Monday, I think. And if I might say so, I can well understand why. So very many congratulations, and I hope you have a good day on Monday. You'll be staggered to know that we won't be giving judgment here and now. The judgments will be provided to you in draft in the normal way for you to correct our English and typing, but not, of course, to attempt to re-argue the case. We'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would seek to deal with the points in the order that we make. And then finally, although I know you will all be very well aware of this, I ought to remind you of the importance attached to the embargo. If at the stage you receive the draft judgment, you think of anybody else who ought to see the draft before it's handed down, you obviously need to come back to us. But thank you all again.